My name is Olivia Hariharan, like Kristin said. I haven't had the chance to meet many of you. I started at the beginning of 2022, and it's wonderful to be a part of Tonkon Torp's Labor and Employment Group, and I'm excited to present to you today. As Kristin mentioned, Carlie and I have split up this topic, the hybrid workplace, because it is a big one. There are lots of potential things that we could talk about today. We are not going to cover them all, but we're going to give it our best shot. So let's get going. A little bit of an overview for you. I think it's fun to start with a bit of a sense of the current state of hybrid work. Going to show you some stats, see what people are thinking and feeling about hybrid work moving forward. Then I'm going to talk with you about employee monitoring and surveillance, which is not necessarily new, but has increased in this era of increased remote work. And then Carlie's going to take over and she's going to discuss remote work agreements and policies and some other jurisdictional issues that come up for folks who are working in a hybrid model. So that is where we're going today. To start, let's chat a bit about the state of hybrid work. I think this is something we're all curious about personally and for our organizations. What people are going to want moving forward. So there's some interesting statistics out there. This is a Gallup poll that was done. And this is sort of current and anticipated employee work locations for remote capable jobs. I think some of the more interesting statistics to compare are looking at the fully on-site work location pre-pandemic was at 60%. And if you look all the way over right-hand bottom corner, it looks like only about 9% of people want to be fully on site in the future. So that's sort of the biggest gap I'm seeing in this chart. I don't think it's particularly surprising to anyone who's been working in an office setting as of late that a lot of people have decided they prefer some sort of hybrid model. They don't want to be fully on site all the time, except for those 9%. Otherwise, there's pretty large consensus that most people, 59%, want to, be some sort of hybrid model, and then there's about a good chunk, 32%, who would prefer to be fully remote. I don't think these are super surprising numbers, but informative nonetheless. A way of looking at the same information, if given the option to work partially remote, how often would people prefer to work at the office? Again, some interesting statistics here. Looks like 4 in 10 want to be in 2 to 3 days a week, and 3 in 10 want to be in the office less than 2 days a week. So there's sort of a critical mass there hovering around 2-ish to 3-ish days in office. Again, anecdotally, that's sort of been my experience, but it's interesting to see this data on a wider scale. And then at the fringes, you've got some folks who want to be primarily in office and some who rarely want to be in office. Additionally, a big question that's been sort of moving through Tonkon and other businesses is if we're going to have a remote hybrid style workplace, how are we going to organize that? According to this data, there's about 6 in 10 who agree that there should be some level of coordination about when people are coming into the office, but folks can't agree about what that coordination looks like. About 24% are excited if the employer would require a certain number of days a week for folks to be on site. 16% say they want their team to be on site on the same days. And then 22% is saying they want folks all to be together for at least 1 day a week. And then 4 in 10, which is still a sizable, amount of people, prefer to have total autonomy about when they come in. So I think there's going to be some interesting conversations here about if we're using a hybrid work model, how are we organizing that in order to maximize the benefits of a hybrid model while also maintaining company culture and collaboration. So these are hot topics that a lot of people are. And last chart before I get into some more details, this was just kind of interesting. It's a comparison by generation of people's preferences about where they're working. Frankly, I was surprised that there weren't bigger differences in these 3 columns, particularly for full-time in office. It's pretty much hovering right around 13% of people, according to this poll, who want to be fully in office regardless of your generation, which is interesting. Obviously, we're seeing some bigger differences there in the light blue, which represents folks who want to be in 1 to 2 days per week. But most people have decided that full-time office work is, not for them across the generations. Interesting statistics to start the morning. And again, anecdotally seems to align with what I'm hearing internally here at Tonkon and from clients as well. Let's move on to my second topic, which is employee monitoring and surveillance. So like I mentioned at the beginning, people have been monitoring their employees for a long time. What we're seeing now is an uptick in that monitoring because people are working fully remote, and also there's improved someone to monitor these things. So some examples of employee monitoring. Probably know about keystroke and mouse monitoring, essentially just keeping track of how much you're typing, how much your mouse is moving. You may have also heard about how people are getting around these technologies by ordering mouse jigglers that basically keep their mouse moving even when they're not at the desk. There's also some programs which will actually take screenshots of the workers' work throughout the day to make sure that they're working on work-related stuff. Some of the more intensive monitoring systems will actually use a laptop's built-in camera to take photos of workers throughout the day, which is definitely a newer technology. And then there's also folks who are monitoring idle time, which is just sort of the inverse of the keystroke and mouse monitoring systems. And then kind of older styles of monitoring would include, reviewing email communications and keeping tabs on what people are doing on the internet. So those are less new. Some of these more specialized monitoring systems and softwares are newer, and we're seeing them being used a lot more as people are working hybrid or fully remote. And the reason I want to talk about employee monitoring today is because there's a lot of laws that are implicated by these programs. And some of them, many of them, sort of fall outside of the typical employment law umbrella, and therefore might not be at the forefront of our brains. So I think it's worth diving in a bit to the laws that are implicated. The three I want to cover today are wiretapping laws, claims for invasion of privacy, and monitoring specific laws, which we've seen an uptick. So let's start off with wiretapping, which admittedly is like the most complicated and most technical of the three. Hoping you all have had some coffee this morning and you're ready to dig in. So before I get into the nitty-gritty of the federal wiretapping law, it's probably good to just talk a bit more about general themes. First of all, when we talk about wiretapping, the classic example I'm thinking of is something from like a mystery movie where there's two criminals that are talking over the phone, and then someone picks up a third phone and is listening in and transcribing whatever the conversation is between the two criminals. That is wiretapping. Obviously, that's not as relevant in the employment context. The situations that are more common for us in this room today would be things like this webinar that we're recording today. Recording educational webinars, recording internal Zoom or Teams meetings, or recording phone calls between employees. So that's where this is going to come up more often for us. So that's sort of what I'm talking about when I say wiretapping. It's a broader concept, which also includes this sort of what I call eavesdropping, which is where basically a couple of folks are chatting in a room and there's a third person or a fourth person who's listening in but isn't part of the conversation. Wiretapping and eavesdropping laws kind of go hand in hand. They're both sort of monitoring and prohibiting the same conduct, which is listening in or recording on something that you don't have consent for. But that's the overall topic. And like I said, I think this comes up most frequently when we're trying to record internal meetings or record phone calls, particularly now that we're relying on Zoom. So that's what I mean when I say wiretapping laws, eavesdropping laws. I think another important point about this area is that these are criminal statutes. So they fall far outside of our usual employment world. And that means they carry criminal liability if you break them. So that's why it's important to talk about these, to be aware of these, and to know how to avoid breaking them. So that's an important thing to note. As I mentioned, wiretapping laws are really technical, very complex, and they vary by state. When you're talking about conversations between two people, oftentimes over Zoom or phone, often those folks are in different places. So not only are you dealing with laws that are complicated in your own state, but you're also having to ensure compliance with other states' laws as well. So as you can see, this gets layered and can be complicated, but I have sufficiently frightened you. There are pretty straightforward solutions to avoid breaking these laws, and we'll get into those as we move along. So all that to say, let's just dive into the federal wiretapping law. The Federal Wiretap Act generally prohibits a person from intercepting or attempting to intercept any wire, oral, or electronic communication, and then from disclosing the contents of that communication. So that's, pretty straightforward. You can't intercept or try to intercept some sort of communication, whether it be over a wire, telephone, Zoom, etc. And you can't disclose that unlawfully intercepted communication. You can record, for our purposes, such a communication if you get the consent to do so from at least one person, one party who's participating in the communication. So frequently, that one person who consents is going to be the person who's recording, and that's sufficient under federal law. As we'll see, that's not enough under state law. But this is sort of the baseline where we can start. And there's several states who follow this federal model, which is only one party needs to consent. And then there's a whole nother group of states which follows a different model, which requires that everybody consent. So this is an example of that one party consent model, which is I'll quickly note there's a lot of exceptions to the Federal Wiretap Act and the other wiretap statutes that I just don't have time to get into today. I'm going to keep it sort of focused on what you need to know as an employer. But as you can imagine, there's exceptions for law enforcement, that sort of thing. So just something to be aware of. Subpart to the Federal Wiretapping Act, it's called the Stored Communications Act. And that basically has certain requirements for the storage of electronic communications. It's basically geared towards companies that are like email servers and are holding on to data from a bunch of different companies. But just know that that Stored Communications Act is a subpart of the federal wiretapping laws. But as long as you're internally accessing your own, your own data within your own policies, emphasis on in line with your own policies, it shouldn't be an issue. But that is a component of federal wiretapping laws to be. I'm going to talk a little bit today about the laws in Oregon, Washington, and California, because like I said, we're often chatting with folks who are outside of our state, and it's probably most likely that we're talking to people on the West Coast. So in Oregon, we have kind of an interesting wiretapping law model that depends on the medium by which you're communicating. So if you're in person, or you're talking over Zoom or Teams like we are today, then everybody has to be informed that the conversation is being recorded to be in compliance with these laws. So that's why Kristin had that beautiful announcement at the beginning of this presentation, and why we provided you notice in writing beforehand, among other checks, to make sure everybody is aware of the fact that this is being recorded today. If you're talking with someone by radio or phone, then it's just one person that needs to consent to the recording. So Oregon's kind of an interesting state because it has some elements of the one-party consent model and some elements of the two-party consent model. But for our purposes, if you're recording Zoom meetings, if you're recording phone calls, even phone calls, I think it's smart to just say that they're being recorded regardless of medium, to make sure that everybody is aware of that. In Washington, everybody has to consent to the recording, regardless of how that communication or conversation is happening. What's interesting in Washington is that the announcement that the communication is going to be recorded should itself be recorded. So again, that's part of why we started the recording. Kristin made her announcement and then we continued. So that sort of element is specific to Washington, but it's a super smart thing to incorporate across the board, even if you're not chatting with folks in Washington. So again, in Washington, everybody has to consent, and you need to make an announcement at the beginning on the same recording that a recording is about to follow. And then California. California has two laws, one that's wiretapping and one that's eavesdropping, which eavesdropping is that model where someone is like outside of the room, sort of eavesdropping on other folks having a conversation, but they themselves are not part of the conversation. Although they have different statutes in California, you need consent from everybody, regardless of whether it's categorized as wiretapping or eavesdropping. So I think that's the most important takeaway. Is again, California requires that everybody consent to any sort of recording, be it over phone, Zoom, in person. I think too, it's worth thinking about not only you as the employer initiating the recording. Oftentimes we're seeing employees doing the recording, right? So sometimes surreptitiously, they don't realize that this is an issue. They're perhaps recording the meeting on their telephone, or they're videoing the video of the Zoom meeting. So I think it's worthwhile to explain this to your staff, and perhaps have a Zoom policy, which we can help you formulate so that everybody's in agreement about what recording looks like and what is required to do so. And oftentimes this will come up, without any malintent. Employees are just better audio learners, for example. They want to be able to look or listen back at the meeting that they just had for whatever reason, but just frankly aren't aware that notice needs to be given before they can record these sorts of meetings. Like I said, we are happy to help if you'd like to develop that sort of policy to make sure that everybody knows how to properly comply with these laws. Move on. So as I mentioned, invasion of privacy. Oregon, Washington, and California all have employees in those states can all bring invasion of privacy claims against their employer. There's a lot of requirements for an employee to win on that claim. But for our purposes, the most important element that the employee has to prove is that they had a reasonable expectation of privacy that was breached. The way we can buffer against that as the employer is saying that you don't have a reasonable expectation of privacy, particularly in things like work email accounts or work technology, right? So that can be in our policies, and we can make announcements about that. When those things are in place, courts generally have agreed that employees are less likely to have a reasonable expectation of privacy, but it's important that those things are spelled out in a policy and communicated to employees. A big caveat, of course, is there are places in the office where someone does have a reasonable expectation of privacy, like, restrooms, locker rooms, that sort of thing, about those areas. But for employers to make announcements that, you don't have privacy in your work, sort of insulate against potential invasion of privacy claims. All right, and then there's also sort of a new wave of employee monitoring specific laws. So these are laws that states are passing in sort of direct reaction to the increase in employee monitoring softwares and technologies. At this point, we've got New York, Connecticut, and Delaware that have already passed this kind of law. And they have their own sort of elements, but basically they require the employer, to provide notice that they're using these employee monitoring practices, and oftentimes also require that the employer explain why they're using them. California has proposed a more comprehensive bill that hasn't yet passed, and also the National Labor Relations Board, which is kind of Kristin's territory, has recently published a memo in which it's promising to crack down on monitoring and surveillance that interfere with an employee's Section 7 rights. So the rights to self-organize, form unions, to collectively bargain, discuss employment conditions, etc. It's important to know that all employees have Section 7 rights. It's not just union employees. So even, it's something to be aware of, even if you don't work in a unionized workplace, that the National Labor Relations Board is taking a hard look at super intensive monitoring techniques with an eye toward protecting employees' Section 7 rights. So with this wave of new laws being passed and the NLRB publishing this memo, we can only anticipate that more laws are likely to come. So it's something to keep an eye out for moving forward. And some takeaways. Basically, I'd say you only want to record meetings if you need to do so and there's a legitimate business purpose for doing it. If you do want to record, I think it's best to provide written advance notice that the meeting will be recorded. So perhaps that's in the, in the meeting invite itself, perhaps it's in the email you send around. Even better if you can secure written advance consent to the recording, which is why we incorporated that in part of our registration process here today. I think the other big one is announcing that the presentation will be recorded at the beginning of the presentation. Like I said, that's a requirement in Washington, but is a good idea across the board, should be a normal practice. And make sure, like I said, you're recording that announcement. And then also, I think this is probably standard, but if it's not, you want to make sure that the Zoom function is turned on, which prompts participants to actively consent to the recording. If the person doesn't consent, they're kicked out. But I think it's good to make sure that function is turned on when you're planning to record. And you can pull a report directly from Zoom, which indicates which participants have clicked that button and consent. Another great way to show that you've crossed your T's and dotted your I's on that front. I think it's also a good idea to disclose monitoring systems that you're using and explain why you're using them, even though in Oregon, Washington, and California, it's not necessarily required by law yet. I think it's a good practice to be open. And lastly, you want to reiterate in your policies that employees don't have a reasonable expectation of privacy on their work devices, work email, that sort of thing. And like I said, we're happy to help you draft policies to meet all these needs, whether it be related to Zoom and meeting recordings, whether it be related to expectations of privacy, etc. That's all I have. That was a lot to take in at 8:30 in the morning. But thank you for hanging with me, working through some sort of technical nitty-gritty stuff. Hopefully you have some clear takeaways from this slide that you can use moving forward. And with that, I'm happy to pass it along to Carlie.
Hi, everyone. Thank you, Olivia. My name is Carlie Bacon, and today I'll be shifting our focus a bit to more just remote work in general. And so specifically, we're going to be talking about potential policy considerations and agreements for you to put in place for your employees. And, I know here it is, the end of 2022. Remote work at this point for some of your workforces might seem like old hat. I mean, we've been doing this for a while. But with 2023 just around the corner, it's a great time to update employee handbooks. Maybe you don't have a written policy for remote or hybrid work in place. And so I thought, let's get into it and go over some different policy considerations. So there are a whole spectrum of options that you can choose from. Obviously, some workers are fully remote. Some may be hybrid, coming into the office and staying at home. Maybe you have the type of workforce where some people are in the office constantly, while others have different situations. Some are fully in person. If that's you, feel free to ignore the remaining 20 minutes of this presentation. So, obviously every workplace is different, and there may be a lot of different options going on. So with that in mind, there's no one size fits all policy. Instead, it's up to you. And if you choose to work with legal counsel, seeking guidance from them, go through and think about what your workplace requires, what your needs are, and then have a good written policy put in place. Because no matter which options you choose for remote work, it's a great idea to have a written policy going over it, for all the obvious reasons, right? Which is to maintain consistency, set expectations for employees, give employees a fair idea of what your responsibilities as their employer are going to be, and also maybe refer to other policies that you have in place that are relevant to them when they work remotely. So we'll be going over kind of a lot during this presentation because I want to touch on a lot of different considerations. I won't spend too much time on each individual one. It's more of a sampling. So with that, let's move on to one of the first policy pointers that we have, which pertains to eligibility. So you may be, or your employees may be asking themselves whether they're even eligible to work remotely. Maybe you want to have a process put into place where they need to make requests. We'll talk about those in just a moment. And where you're approving on a case-by-case basis whether or not they can work remotely. So it's a good idea to put into your policy some sort of note pertaining to their eligibility. And so, for example, maybe you want to, for new hires, you want to put some sort of time period in place. Maybe only employees who have been working for you for 60 days or 90 days or some other period of time are eligible to work remotely. That way, of course, you can assess their performance, make sure it's a good fit before you set them loose to work from home. Obviously, as I mentioned during the introduction, maybe certain jobs just don't work in the remote work world. Of course, like security officers or employees in your staff, like in the office, who need to be performing all of the routine day-to-day tasks like printing, copy, and that sort of thing. Obviously, they can't do that from home. So thinking about which jobs are eligible, and then even within certain jobs, which job duties. So just defining those kind of things for employees to make sure it's clear who's eligible and who's not. Another consideration would be for different types of workers who are either full-time, part-time, maybe you have temporary workers in your workforce. So it's also a good idea to just set out in the policy which of those are eligible as well. So another little reminder here, this might be a good time for employers to update their job descriptions as well. Later on in the presentation today, Blerina will be talking about ADA considerations. So this sort of feeds into that a little bit. But having a good job description in place and identifying what essential job functions are, including whether attending work in person is an essential job function. That can be a really fact-intensive inquiry. And so that's something we do recommend you would seek legal counsel on. So just going to make a quick plug for that. So once you've defined eligibility in your policy, another thing to consider is, do you want to have employees make specific requests, or maybe you prefer to have a blanket policy of, anybody within this job category gets to work remotely. It's just sort of an announcement company-wide, and it's an expectation. Plenty of employers have that more flexible approach, but the upshot to having a formal request procedure in place is that as an employer, you maintain discretion over which employees get to work remotely and which don't. If you do choose to go with a request procedure, it may be worthwhile for you to consider using a standard form. What information you choose to request from employees, you might look at, of course, their tenure, their job position, those kinds of things. It's a good idea to have a request in writing as opposed to verbally, just for your own record keeping purposes. If you do go through a request process, so as opposed to just having a blanket expectation that certain employees can work remotely, if you're in the realm of a request process, it's a really good idea to include your human resources department within that process. Or if you don't have a formal HR department, then maybe multiple supervisors or managers involved in the process, so that there's more of a consistent review in place. And this is just to try to prevent any sort of discrimination and retaliation concerns. because of course, a lot of people love to work from home. And if an employer is picking and choosing which employees are able to work from home and which are not, even if the employer has the eligibility defined in their written policy, and accept or decline requests based on those factors, you may still have disgruntled employees who feel that they should get to work from home for whatever the reason might be. In their minds, maybe it could be something that's discriminatory based on their age or their race or some other protected characteristic. Or perhaps recently in time, they made some sort of complaint or participated in a company investigation. And so now being declined the opportunity to work remotely to them might feel retaliatory. So by including HR or having other people involved in the review process, not just having it be within the discretion of one supervisor, is a good idea to try to alleviate those kinds of things. Another thing you might consider within the eligibility and request process in your policy is implementing a trial period. So just like with having a minimum eligibility tenure before approving requests, having an employee work remotely for maybe 60 days, 90 days, and then assess their performance at the end of that time. And in the meantime, also maybe having specific check-ins, like weekly check-ins with their manager, so that you're keeping close tabs on their performance, and of course documenting those things, so that at the end of the trial period you can make an assessment of whether or not that remote work situation is working well for them and for you as their employer, and if any adjustments need to be made. So a trial period is another thing you might consider for your policy. And then finally, within the request realm, what kind of approval process you want to have in place. We would recommend that if you were to have your requests in writing, it might be a good idea to also have your approvals in writing. And then you also might want to consider implementing a written remote employment agreement. Again, that really formalizes the process. At this point now, we're talking about multiple documents in place for this, but especially in the situation where you maybe have employees who work out of state or even out of the country, where they're not being supervised and not regularly reporting to the workplace. So maybe you're fully remote employees, for instance, having that employment agreement in place just further solidifies the expectations that you have for them. And, it's just excellent record keeping. So that's something you might want to consider implementing as well. So moving on, well, actually not moving on, this is still part of the request process. You want to be sure to exclude any sort of accommodation requests. And so that's something that as an employer, it's a good idea to check in with your HR folks, definitely check in with your supervisors and your management, so that they are mindful of employee requests to work remotely that might actually be requests to work remotely based on either a disability that the employee has, or even a religious practice. You might be thinking like, well, what could that possibly be? For example, if an employee has a really strict prayer schedule, for instance, and maybe they request to work remotely so that they can go through their prayer schedule at home and have what they need there. So just being mindful that if an employee requests to work remotely as an accommodation for a disability or as an accommodation for a religious practice, that those should be assessed under your policies having to do with reasonable accommodations, assuming, of course, that you're covered by these anti-discrimination laws, which federally for disability is the Americans with Disabilities Act, and there's a state equivalent here in Oregon, and for religion it's Title VII, and there's also a state equivalent here in Oregon. So if you're covered by that and you've got an employee making a request that might fringe on that even a bit, move away from considering their request under your remote work policy, and instead put them in on the right path to engage in the interactive process and handle their request that way. So moving on, another section in the policy that you would want to lay out, and this is especially where it really depends on what kind of workforce you have, is setting out employee expectations. So for instance, are they going to be fully remote, or are they going to have a hybrid schedule? If hybrid, what days do you expect them to report to work? Should they be coming in with their team, or do you want your entire workforce to be reporting to work on the same days? Are you going to permit remote employees to have a flexible work schedule, especially those, for instance, who are working maybe on the East Coast or out of the country? Are you going to have any sort of core work hours where they're expected to be available and working? Those are all things that you'll need to assess, obviously, on a case-by-case basis with different employees. Another thing to consider putting in your policy, or at least consider for your practices, is whether or not you might want to implement shared workspaces. Because of course, if your entire workforce isn't coming in regularly, then maybe you don't need the same in-office resources that you once had. So maybe you'll have employees who are hoteling by checking in and using desks on a shared basis. If so, it might be a good idea to lay that out and give your employees notice of it in advance. Another consideration really that feeds into the first bullet point, which is just their accessibility during work hours. To what extent, when they're working remotely, do you want them to be accessible? Maybe it's on one end of the spectrum, they're on Teams or they're on Slack and they're responding to messages quickly, like almost in real time. Or maybe it's more, if they get a call from their supervisor, then they need to call back within an hour. There are endless options. And it of course, depends on your workforce and your employees, but those are that's another consideration to think about. Another expectation that would be good to set out in your policy is that working remotely is, of course, not a replacement for employees having childcare issues or dependent care or pet care, even though, of course, that's convenient and you might have a little overlap. You don't want to get into overlap situations like that. So setting that expectation out is a good idea. Also, maybe you would like to implement or maintain a dress code for people who are working remotely. If you have the type of workforce where employees are expected to jump on a Zoom call or a webinar quickly and be on camera, maybe you'd like to set the expectation that when they're working remotely, they're not just wearing, their underwear and laying in bed. They need to actually be presentable in the home. Another expectation to set out is that dealing with timekeeping and meal and rest breaks. So of course, this doesn't apply to your exempt employees, but to the extent you have any non-exempt employees who are working from home, so those who are hourly and subject to meal and rest break requirements and overtime requirements, it's a good idea to have a note of that in your policy, or at least maybe a reference to your timekeeping policy. Because of course, under Oregon wage and hour law, employees are entitled to be compensated for all hours worked. When they're working remotely, of course, it's a little more difficult to see when they may not be working, when they may be taking their meal breaks and their rest breaks, and whether those are compliant. So it's a good idea to remind them that they're expected to mind the timekeeping policies. Okay, so outside of employee expectations, and that's by no means an exhaustive list. I mean, there may be expectations that are specific to your workforce. But in addition to those, it's nice to also give employees notice of your responsibilities or the agreements that you're willing to make with them about their remote work situation. And so just a few for your consideration are what equipment you might supply to them. Are you going to provide office furniture? Are you going to give them a desk? Those kinds of things. Technical support. gosh, I rely on that so heavily. I can barely use Microsoft Word. So, having technical support for their webcams and their internet service and their virtual machines and access, setting out what that is and giving them a line of support is a good thing to put in your policy as well. And then this is not really something that I would encourage you necessarily to put into a written policy, but just a best practices reminder is that as an employer, you're responsible for enforcing your policies, even though they may be working remotely. And so just as an example, an illustration, harassment, that can occur outside of the physical workplace. And so harassment can come in the form of harassment by coworkers, supervisors, or even third parties if it's connected to their work, such as customers and clients that your employees are interfacing with. As you know, those can all be sources of harassment, and they don't need to be in person. They can be in the home. I actually dealt with a case somewhat recently where all of the alleged harassment was occurring on Instagram, where employees followed one another and were posting very mean, like memes and photos, and then making it very clear in the comments and the caption that they were referring to certain coworkers, which those spread like wildfire. And that was the basis for a harassment lawsuit. So basically, it's just a general reminder that the workplace policies apply, even if the employee's workplace is their home. So keeping that in mind. All right, so sort of relating back to the previous slide, which is what equipment will you provide as an employer? Another one is which expenses will you choose to reimburse? And of course, this is covered by certain laws. Here, I just give you a quick sampling of Oregon, California, and Washington. But of course, if you have employees who are working in other jurisdictions, then you'll need to look at those laws and see what applies to them specifically. So I won't bother reading that all out because it's quite a bit of text. But as you can see, there is quite a bit of variety between them. And I will share with you an interesting case that happened in California recently. This was a federal lawsuit against Amazon. So looking at the California standard first, just to get us all on the same page. California's labor code requires that employers reimburse for any sort of necessary expenditures, including all reasonable costs. And so what does that actually mean? Because it's pretty vague. Down in California, a senior software engineer working for Amazon filed a lawsuit in federal court, and he alleged that Amazon failed to reimburse him for certain work-related expenses like his internet. Amazon filed a motion to dismiss, and they raised a couple different arguments, but the one that I think is most pertinent for our discussion today is that Amazon argued that because the employee did not submit any requests for reimbursement, they were off the hook. They didn't know that he had incurred any business expenses, and so they weren't liable for them. Well, the court didn't take too kindly to that argument. They denied the motion to dismiss, and they explained that Amazon is a tech company, and the plaintiff, their employee, is a software engineer. So Amazon, should reasonably know that his job duties as a software engineer will require the use of some physical space, and he'll need to have internet and he'll need to have electricity in order to do his job. So even if he didn't submit a reimbursement request to Amazon, Amazon either knew or they had reason to know that he was incurring those basic costs. So they were not off the hook just because he didn't request it. So then, in California, basic costs can be internet usage, personal cell phone, laptops, and even some utilities. There also have been some recent activity where employees are seeking reimbursement for furniture, rent, and even their meals in cases where they have employers who provide like snacks in the physical workplace. So I mentioned that obviously, you know, we're not physically here in California, but I know a lot of you have work sites in California, you have employees in California, and it also just helps illustrate that this is a fact-intensive thing, what kind of expenses you might be on the hook for reimbursing. And so it's a good idea to have that clear policy in place and practice. All right, so moving on. This is more of, again, like a best practices highlight for you. You don't necessarily need to include this in a remote work policy, but you might make reference to it if you like. And that is remote work injuries. So remote workers are still eligible for workers' compensation. And that's because workers' compensation applies to any injury or illness that occurs in the course of employment. Well, of course, if your employees are working from home, they can occur in the course of employment. Same goes for injury reporting requirements for OSHA. As a reminder to you all, Oregon has its own OSHA as well, and other states do too. So you'll want to be mindful of that. And you might be wondering, well, how could they possibly get injured when they're, you know, sitting on their couch with their golden retriever wearing their pajamas on their laptop? Well, OSHA actually gave a couple of examples of what is and is not considered work-related. So a work-related injury might be if an employee is carrying a heavy box of documents in their home and they drop the box of documents and it falls on their foot and hurts their foot. There you have a work-related injury. Another example they gave is an employee who is rushing through the home to answer a work call because they hear their phone ringing and they trip over the family dog and get hurt. OSHA says that's not work-related. And they didn't really give a whole lot of illustration as to why, but I might speculate that because even though you're rushing, or the employee was rushing to answer a work call, you know, the family dog is not typically a work-related hazard, and something more specific to the home. Another example they gave of something that is not work-related is an employee who is electrocuted by faulty home wiring. And I found that interesting because just a moment ago, when we were talking about reimbursements for work expenses, we talked about how California basic costs include internet and cell phone, laptop, and some utilities, which includes electricity. So, you know, there's a little bit of a divergence there. On the one hand, those are work-related basic costs in California that should be reimbursed. But on the other hand, you know, if you get electrocuted from your electricity at home, that's not considered work-related for purposes of OSHA injury reporting. Okay, so enough about that. Let's just move on here to the end, which is some additional policy considerations that you might want to make reference to in your remote work policy, or just things for you to think about as you're updating your handbooks and your other policies, which is a bring your own device policy. That one can set clear expectations for employees about using company resources or their own devices and the extent to which they overlap. Obviously, that's quite relevant for the remote work setting. Outside employment, you know, maybe you've got some remote work employees who, you know, log off and go drive for Lyft or Uber or do DoorDash to make a little extra cash on the side. You know, you might have some issues there. So having reference to your outside employment policy or putting one in place so that you have the opportunity to correct that kind of behavior if it comes up is also a good idea. Making sure that your confidentiality and trade secrets and relatedly your information security policies are up to date and tightened up. Of course, when you have employees using company resources at home, like their computers and their cell phones, those issues really come into play. And then finally, a reminder that all of the notices that employers are required to physically post in the workplace, you know, when you have fully remote employees who aren't able to come into the place and see those things, employers are still responsible for making sure they get those notices. And I'll tell you that it depends on the jurisdiction. In large part, those can just be emailed to the employee. That's pretty easy. But some still require that a physical copy is received, in which case, of course, you can just mail them to the employee's home, but it's worth looking into where are my employees, what notices do I need to give them, and how do I need to get them to them, just to make sure you're fully compliant. So that was a nice big survey, and I know that was a lot of content about all the different policy considerations that you might put into place for your remote workers. And then now we're just going to touch on a related topic, just briefly, which is some jurisdictional issues that come up with remote employees. And so, for instance, which laws apply to remote employees? Well, it honestly depends on the particular law and the rule, and court and agency interpretations. It might not seem all that clear, especially when you have an employer in one location and an employee in another, and work being performed possibly in another jurisdiction. So, you know, at the risk of going down a rambling path of a pretty complicated area, I just do want to flag for you that that can be a very specific inquiry depending on the law. So it's important to assess each remote employee's circumstances to figure out which laws apply to them so that you're following those. And then on a related note, remember to properly count your remote employees. So for example, the FMLA defines a work site as the employer's office to which the employee reports and from which assignments are made, not the remote employee's personal residence. So this is important when determining whether a remote employee is eligible to receive benefits under FMLA and whether a certain work site counts as FMLA covered. You need to make sure that you're counting those employees within that properly, and not relying on their home being a work site, because it's not. Same goes for the WARN Act. So this federal law applies when employees do shutdowns or layoffs, and need to provide notice to their employees of that, and various other requirements that are way beyond the scope of today. Similar to FMLA, the single site of employment, which is related to the location, it's the location to which the employee is assigned as their home base, from which their work is assigned, or to which they report. Again, not their home itself. So those are just a few things to keep in mind for your remote employees. And then finally, related to jurisdiction, is work from anywhere. This is different than work from home, because this applies to employees who choose to maybe travel to some fabulous locale, or, you know, head to another state. I've heard about employees not informing their employers and just moving to a completely different state and had been working there for a while and the employer had no idea. They're also, I heard of an employee moving to London and didn't tell their employer. And then, you know, on the other end of the spectrum, the sort of the vacation side, and I've even seen the term workcation. I don't know if that one's going to take off, but it's out there, workcation. Employees going to fun destinations. So, you know, for instance, heading off to Palm Springs for a month to work remotely. Just like on the previous slide, when we talked about there's a fact-intensive inquiry, which laws apply to which employee based on where they're working, where their work is being felt, or, you know, where it's being done, and then where the employer is based. This really comes into play if they're working internationally or in a different state that you don't have a business location in. So for your policy, or at least in your practice, you may want to address work from anywhere with your workforce. You may want to consider limiting the locations where employees can work So for instance, you might want to limit them to jurisdictions where you already have a business presence. So if you have an office in California, employees can work remotely in California, but you don't have any sort of business presence in New York. So you don't want employees going there and having to get into the weeds on all of the New York employment laws that might cover them. So limiting locations. Another is limiting the time that they work in certain locations and having mechanisms to track that time. Again, just to help curtail your potentially being covered by countless employment laws. You may want to make clear that employees who are traveling around to work from anywhere are responsible for their own shipping costs and providing their own equipment, so that that's not on the company dime. Of course, like we talked about earlier, work schedule in different time zones if they're in an international location or far away. Another is making clear that employees are responsible for their own transportation, meals, lodging, just making it absolutely clear to them that although they may be traveling to go work in a remote location, that travel is not a business expense. Another being that the travel should be done in non-work hours, so they're not on the clock when they do that travel. And then also for any sort of employees who are working in different jurisdictions, making clear that you as their employer are not responsible for and not giving them any tax advice, and that they should be consulting their own tax advisor for issues about their jurisdiction. So that does it. I know that was quite a bit, but of course, if you have questions and are wanting to fine tune your policies or put a new policy or employment agreement in place, recommend that you reach out to your legal counsel. And with that, I will say farewell for Olivia and for me. And next up is Jordan, who will be presenting on paid family leave. Thank you.
Paid leave Oregon is finally here. So why do I say finally? I like to kind of put this into context because we've been hearing a lot about paid leave Oregon for years at this point. It was signed on July 1st, 2019. This picture here, also taken July 1st, 2019. It was my first day back from maternity leave with my son there. This next picture was just a few weeks ago. That little baby is now that big kid in the back, and I've had a whole other child since then. So this idea of paid leave Oregon has been floating out there in the ether for a long time. It's something that employers have been anticipating for a while, maybe feeling some anxiety. So we're here to kind of cover all of that. So here's kind of the laundry list of things that we are going to go over, and the timeline, the benefits, eligibility. There's a lot to cover. It feels overwhelming, but remember, one of the nice things about paid leave Oregon is it's primarily administered by the state, not by employers. There are still, of course, things that employers need to do to comply with it, but a lot of this stuff, especially a lot of the technical math stuff that we'll go over, is handled by the state, which should be great, comforting news. So, timeline. You'll notice the first deadline here has already passed. Back last week, November 30th, equivalent plan applications were due. That won't be the only deadline for equivalent plans, and we'll chat about that later, which is why I left it up there. But that was the deadline to avoid payroll contributions that start on January 1st. So January 1st is when payroll contributions will begin for employees and employers. And then benefits will begin September 3rd. So the question we always kind of get with paid leave is, who's paying this and how much? You know, when we think about paid leave, we think about an employer paying an employee to be out on leave. That's kind of the traditional American model of paid leave. But this is not that. Paid leave is coming to employees via the state. It is like an insurance program. So employers and employees are paying into it using payroll contributions, and then employees are taking out of it from that fund through paid leave Oregon. So unless you're doing an equivalent plan, which we'll talk about, And in an equivalent plan, you would be the one paying the employees. So other than that, it is the state that is providing those funds to employees. So how much are they earning? These are one of the math items that I'm going to say we are grateful that we don't have to do and that the state is taking care of. So the amount that Paid Leave Oregon will pay employees depends on their wages. So if their wage is equal to or lower than 65% of the state's average weekly wage, then they're going to get 100% of their wages from Paid Leave Oregon. If their wage is more than 65% of the average weekly wage, they're going to get that 65% plus 50% of the wage greater than that 65%. So let's say 65% is here, their wage is here, they're going to get the middle. Again, I'm happy that I will not be doing that math. I imagine many of you feel the same way. The next kind of question is, who is going to be eligible for paid leave? And this is broad. Basically, it's employees who have made at least $1,000 the year before applying. This does not mean they have made $1,000 with you. It's that they've made $1,000 in wages that's being paid into this state insurance program. This is designed to be very broad. For those of you who have employees in Washington and are kind of accustomed to Washington paid family medical leave, that's also very broad. So that's sort of the trend that we're seeing is these very broad laws are meant to encompass many employees. There will, of course, be some people who aren't eligible, maybe people who haven't been in the workforce and maybe their job with you is their first job or their first job in over a year. But your default assumption and my default assumption is that all of your employees are going to be eligible because it is written so broadly. There is also an option for self-employed individuals to be eligible, but they have to opt into that. So let's talk a little bit about what are the paid leave benefits. So this is going to be up to 12 weeks of paid leave a year, or 14 for certain pregnancy-related conditions. This is, again, it's paid by Paid Leave Oregon, and it's a percentage of the wage up to 100%, with employer healthcare coverage maintained. Leave can be taken by week or by day. An employee's job is protected if they have been employed by you for longer than 90 days. And we'll talk a little bit more about that later. The other thing is that employees must give 30 days notice. But the caveat there is that if they don't give you 30 days notice, they still get to take the leave. So if they don't give you the 30 days notice, the penalty for that is between them and Paid Leave Oregon. It ends up being a percentage of their first week's worth of benefits. But again, that's not really something that's in our control as employers, but it's something between them and Paid Leave Oregon. So a reminder, those benefits begin September 3rd, 2023. So the payroll contributions. Contribution rates will be set each year. For 2023, this inaugural year for paid leave, it is 1% of gross wages, and that is split between the employer and the employee. So the employers have 40% of that 1% and employees have 60% of that 1%. Small employers do not need to contribute the employer portion, but all employees must contribute unless your employees are covered by an equivalent plan, which we'll talk about later. But if you do not have an equivalent plan, all of your employees will be contributing starting January 1st. And we'll touch on small employers later and what that means and whether there are advantages to contributing, even though you don't have to. But the default rule is that small employers do not need to make that employer contribution. So job protection. If an employee has been employed by you for over 90 days, they have job protection built into Paid Leave Oregon, meaning that when an employee returns from leave, they're entitled to return to the position that they held before leaving if that position still exists. Now, if the position no longer exists, we see slightly different rules for large employers versus small employers. If the position does not exist and you are a large employer, meaning you have over 25 employees, that employee is entitled to a position equal to the previous position with equal pay and benefits. If you're a small employer, they still have to have the same benefits and pay, but the employee can be restored to a different position so long as it has similar duties. So in either scenario, you're restoring people to a job with the same benefits and pay. They're not getting any demotion when they come back. But if you're a small employer and it is necessary for your business, you can put them in a different position with similar duties. And the thing to flag here is that a failure to provide job protections is an unlawful employment practice. And that should always be a red flag for everyone as we're going through things, because that will be the basis to any potential lawsuit against an employer under Paid Leave Oregon. So let's talk a little bit about equivalent plans. If you already offer paid leave to your employees, you can apply for that to be considered an equivalent plan. If you're approved by Paid Leave Oregon for your equivalent plan, then you don't need to make payroll contributions. Like we talked about before, that deadline has already passed. It was November 30th, unless you filed a declaration of intent, which I know we have some people who have done. We can put a pin in that and talk to you all individually because it's sort of a niche process only for this initial year. But if you miss that deadline and you do provide paid leave, or you want to provide paid leave, they will be considering equivalent plan applications on a rolling quarterly basis. So you have not missed your opportunity, but you will need to start making payroll contributions as of January 1st. So equivalent plans must offer the same or more benefits than that of Paid Leave Oregon. So those benefits are what we talked about earlier, the amount of pay, the 12 or 14 weeks of leave, the health insurance benefits, job protection. Those equivalent plans must be approved by Paid Leave Oregon and go through their approval process in order to exempt you and your employees from making those payroll contributions. So as I mentioned before, we have a couple of things that are a little bit different for our small employers. Now, small employers means employers with less than 25 employees. That inevitably raises questions of how do we count those employees, particularly for those of you who might be right near that 25 employee line. And that's something that Paid Leave Oregon themselves has been trying to figure out. They initially announced one rule. Then after soliciting feedback from Oregon Business and Industry, they changed that rule just a few weeks ago. So to put it kind of simply, air quotes on simply, the employee count is the number of employees on payroll for the pay period that includes the 12th of the month. And it's the sum of the employees in Oregon as well as the employees out of state. So then we take that number of employees on the pay period that includes the 12th of the month, and we average it out over a 12-month period. And that gives you the number of employees that you have for purposes of Paid Leave Oregon. It doesn't include replacement workers for people who are out on leave. Super clear. Thankfully, the administrative rules actually have a ton of really useful examples, which is one of the great things about Paid Leave Oregon. You probably hear me pitch this a few times. They have an extensive website and extensive guidance. One of the nice things about it taking, nearly 4 years for this law to come into effect is they have had plenty of time to put out educational videos, brochures, notice posters, all of this stuff. So their website is a plethora of information. One of my kind of favorite examples, given the season that it is an employer like a Christmas tree farm. So as a Christmas tree farm, you may have employees in November and December, you may have 45 employees during those months. But because of the way that they are going to be calculating the number of employees that you have, it's going to be averaged over that 12-month period. So maybe from January through October, you only have 10 employees per month. That's going to average out so that you're still considered a small employer for Paid Leave Oregon. And, you know, as kind of summarizing that, the small employers, the things that are going to be different is you are not required to make those payroll contributions, and your obligations for job protection are slightly different. One thing to note, it was on this last slide that I didn't say, is if you do choose to make those contributions, you're eligible for assistance grants to help cover the costs, such as temporary workers during an employee's leave. So small employers not required to make those contributions. You can, and if you do, then you're eligible to apply for these assistance grants. So what do all employers have to do? We're talking small, we're talking large, we're talking everybody. So you must report employee wages for those working in Oregon and employee counts for Oregon and out-of-state employees. Because remember, that number that we're averaging from the payroll period that includes the 12th of the month includes out-of-state and Oregon employees. You must withhold and submit payroll contributions. Even if you are a small employer who is not submitting your own payroll contributions, your employees still need to be submitting employee contributions, which of course means you need to be submitting your employees' payroll contributions. You must inform your employees about paid leave Oregon, allow your employees to take that leave. You must maintain existing health benefits for employees on leave, and not discriminate or retaliate against employees for taking this protected leave. And then, of course, the job protection benefits that we talked about before, restoring employees to their position after taking paid leave if they have been an employee with you for over 90 days. On informing employees, I mentioned this previously, but Paid Leave Oregon, one of the many resources that they have is a model notice poster that you all can access via the Paid Leave Oregon website. Actually, I have a link on a later slide that you can print out to be able to distribute to your employees or post in the place where you normally post your model notice posters. So these charts are going to look a little overwhelming. Remember, you're getting all of these materials. These are some charts that I got from Oregon Employment Department that kind of talk about all the other laws that we have in conjunction with Paid Leave Oregon. Paid Leave Oregon is new, but the need for family leave is not new, right? Employees have been taking family leave in various forms for forever. So these are just kind of going over how all of these laws interact. I will note kind of at the outset, you won't see workers' compensation on these charts because workers' compensation is a different process, a different beast, right? So your time on Paid Leave Oregon is separate from any time on workers' comp. Those are not going to run concurrently. They're not going to cover the same things. So looking at this chart here, this one's looking at eligibility requirements. We're looking at Paid Leave Oregon, OFLA, FMLA, and Oregon sick leave. One of the biggest differences for Paid Leave Oregon is there is no work time requirement for your employees to be eligible. You could have an employee that starts on Monday and needs to go on family leave on Tuesday, and they're going to be entitled to take that leave. They won't be eligible for those job protection requirements that don't kick in until after 90 days. But so long as they had $1,000 in wages from any employer in the previous year, they're going to be eligible to take that leave no matter how long they have been your employee. We also have talked about how it really is going to cover all employers. You know, even if you are a small employer who's not making the payroll contributions, your employees are still going to be eligible. So just because you're a small employer, employees of small employers still going to be eligible for Paid Leave Oregon. This chart is looking at the qualifying purposes for these different types of leave. You'll see there's overlap for basically every type of leave that there could be. And any of these leaves like OFLA and FMLA, they're going to run concurrently with Paid Leave Oregon. So if you have an employee that's out on Paid Leave Oregon for this top reason, right? Family leave, the birth or adoption of a child, they are going to be using their 12 weeks of paid leave Oregon concurrently with their 12 weeks of OFLA, for example. Something to note here is paid leave Oregon doesn't cover everything. For example, if you have a sick child, you are not going to be eligible for paid leave Oregon unless it is a serious medical condition. But, you know, if you have a kid, like I was home yesterday with a kid with the flu, right? That's going to be eligible under Oregon sick leave or maybe OFLA, but it's not going to be paid leave Oregon. And then finally here we have the leave duration and the benefits payments. So again, we're looking at this 12 weeks in a 1-year period or 14 as a maximum for certain pregnancy related conditions. This is less than the OFLA and FEMLA, but it's also paid, right? Which is unique among these family law leaves. And then the benefit amount is going to be that variable math equation that we are thankful we are not doing and that paid leave Oregon is taking care of. The most important thing for us to remember is that paid leave Oregon is not going to exist in a vacuum, right? All of these other laws are going to continue to apply. And here we're really just looking at the family leave laws, right? So we're still always going to have the ADA, we're always going to have workers' comp, we're going to have all these other different types of laws that interact in these complicated ways where hopefully you're going to pick up the phone and call us so that we can work through it together, especially as we're going through this first year of trying to figure out when paid leave Oregon kicks in and how to best support these employees as they're going through this. So one of the traditionally unique problems for Portland employers has been kind of dealing with employees that live in 2 different states. Now, with remote work, as Carlie and Olivia discussed, that's kind of a problem for everyone. It's no longer unique to Portland, but we do still have a unique problem of perhaps having multiple work locations for the same employee that are both in Portland and particularly in Southwest Washington. So given the long lead up time for this law, we actually have some rare joint guidance from the state agencies that administer paid leave Oregon and the Washington Paid Family Medical Leave. They issued a joint letter, which I put a link in here for if anyone wants to read it. It, like some of the other guidance, provides some pretty useful examples. Both states are going to first consider the physical location where the work is performed, which is a super easy question if all the work is performed physically in one state. So if I'm always working at my office in Oregon, great. That's, you know, paid leave Oregon is going to be the one that applies. Or if I'm always working at a Vancouver office, the Washington Paid Family Medical Leave is going to be the one that applies. If I go back and forth between the 2 offices, the question is going to become, where's the base of operations, or where does direction and control come from? So let's say I work the same amount in the Portland office as I do in a Vancouver office, but our headquarters is in Portland, my boss is in Portland, they're the ones giving me control and direction. Then it's going to be paid leave Oregon that applies, not Washington Paid Family Medical Leave. So if you work in both states, but direction and control does not come from any of the states in which you work, then the question is going to be where the employee resides. So let's say I work part of the time in the Portland office, I work part of the time in a Vancouver office, but the headquarters for my organization is actually in Tennessee. And so all of my direction and control is coming from Tennessee. Then the question is going to be, what state do I as an employee reside in? I reside in Oregon, Oregon Family Leave or Oregon Paid Leave Oregon is going to apply. And again, there are lots of useful examples in that joint letter to help us as we all jointly try to navigate through remote employees and where they are and what paid family leave systems might apply, particularly because it's not just Washington and Oregon that have paid family leave, right? There are some other states too. So as we have employees from more diverse states, we're going to continue coming across this question. So it's finally happening, right? After years, kind of. Benefits themselves don't start until September. But now is the time to be figuring all of this stuff out that we need to do. Contributions begin January 1st. That is less than a month away. Given the holidays, I imagine it's like 3 solid working days away. So definitely encourage everyone to get in contact with their payroll provider, make sure everything is set up to be making those payroll contributions starting January 1st. It's a great time to update your employee handbook to make sure that employees know about Paid Leave Oregon and the changes that are coming. Educate your employees, educate HR, post that model notice poster. And if you want to pursue an equivalent plan, remember that it is not too late. That initial deadline has passed, but they're going to continue considering them on a rolling basis. So either as we're all figuring it out and you decide you want to do an equivalent plan, you can submit it now. It may be that after benefits kick in September, employers realize that that's not going to be the best fit for their company, then you can explore an equivalent plan at that time. And of course, contact us if you have any questions. We are deep in the Paid Leave Oregon regulations, as you might imagine. I think Kristin last week sent us some light 90-page reading on it. So we are all here and happy to help everyone through this as we also go through it ourselves.
So good morning, everyone. We're just getting back from break. That was a very quick 5 minutes. So I hope that you're feeling refreshed and ready to get on to the next topic. And that is the changing landscape of labor laws in the US. So over the past 6 or 7 years, I give this annual update on labor laws affecting private employers. And this year is a bit different because I won't be going into all the details about the various cases that have been decided by the Labor Board over the past 12 months. Although rest assured, there have been quite a few with large impacts for employers. And on that note, we have been and will continue to send out alerts when there are big changes that you should know about. But today, I want to talk about the headlines that we've been seeing over the past year about the resurgence of unionization with companies like Starbucks and Amazon and Google and on, just to name just a few of the more high-profile employers that have recently experienced an increase in union activity. We'll look at what are the new trends in labor and what is contributing to this uptick in unionization. And importantly, what impacts will it have on your business and workplace? And most important, is there anything you can do about it? Spoiler alert, yes, there is. Let me try to advance my slides. There we go. So some of the highlights that we'll be discussing today are the dramatic increase in union organization efforts, particularly in industries that have generally not been organized. And this includes major companies like Starbucks and Amazon that I just mentioned, most recently Apple, where employees have clinched union victories. Also in industries and market sectors that typically have not unionized, like retail and childcare, restaurants and nonprofits, and a lot more. Also, there is public support for unions that has been making headlines too. So unions and unionization is quite popular right now in the United States. And there are a lot of theories about the contributing factors to this revival in union popularity. Some involve the sentiment and values of a younger workforce. And some involve workers' wariness after enduring a multi-year pandemic. And of course, we all currently have a very union-friendly president and labor board, as well as the National Labor Relations General Counsel. And we'll talk about her in a moment. So for those of us who practice labor law, what we are seeing happening with the uptick in union organizing and the public popularity is similar to also what we're seeing at the bargaining table when we actually have unions and we're sitting down to do collective bargaining. And that is, workers are dissatisfied right now in the workplace. And there is a level of hostility that I haven't really seen. It's pretty new and fresh. And they really seem to be fed up with the status quo, whatever that is at your workplace. Importantly, they want a voice, and they are demanding some pretty dramatic changes, and more than just wage and hour benefits that we usually bargain around. They are seeking to bargain over changes to work-life balance. They're seeking to change how they work. And also they want to have a say in the company's culture. So these are very interesting times in labor. So started, let's revisit the basics about the National Labor Relations Act. It was enacted in 1935 as part of the New Deal suite of legislation. Its aim was to govern labor unions, process elections for employees who want to unionize, oversee the collective bargaining process, resolve disputes between employers and unions, and enforce the National Labor Relations Act by investigating violations of the law and holding the transgressing party accountable. So the National Labor Relations Act, I'll just keep calling it the Act, it'll be easier. So the Act creates a board. It's a 5-member board, which is comprised of 3 members from the president's party and 2 from the other. So now there are 3 Democrats on the board and 2 Republicans. All of the positions are appointed by the president and confirmed by the Senate. The board oversees the adjudication of unfair labor practices. Those are the violations of the law that I just spoke about. They oversee union election disputes and so on. And I sound like a broken record here, but what we've seen is over the past 40 years, the board has become very political. And as one court put it, fickle and unstable. And I would have to agree with that. So the law that is issued by the board is driven primarily by politics, and it will change from one administration to the other. So this means that prior decisions carry no weight. Rather, a board will seek to apply its own liberal or conservative agenda. And we've experienced this flip-flopping between the Reagan board and the Clinton board and the Bush board and the Obama board and Trump board, and now the Biden board. So the law is constantly in flux and depends on who's in the White House. I wish I could say, I just advanced to the next slide. Sorry about that. I'm running 2 different machines. So I'd like to say that, this is going to change and stabilize, but we don't expect it to change. And we predict that the opposing sides are becoming more and more entrenched and more extreme. So essentially, we might need a neck brace to survive the whiplash of the board. But also, what I'm going to focus on a little bit today is the Act also creates the position of general counsel. And this is another position that's appointed by the president and confirmed by the Senate. And this is a very important position. Arguably, in my humble opinion, it's the most important position at the agency. So the general counsel oversees all of the field offices across the United States. And those field offices are who do the investigation and prosecution of unfair labor practice charges, and they run elections and those types of things. So the general counsel also has a very important power, and that is that she oversees the division of advice. So the division of advice is the interpretive arm of the National Labor Relations Act, and it determines what the labor law is or should be, which might be contrary to what the current law is. And so the general counsel will select cases to be prosecuted so that the board will have an opportunity to change the law formally. That's all saying that the general counsel really is the gatekeeper of the cases that the board will eventually rule on. And remember, the board and the general counsel are selected by the president. So they do work hand in hand. My goodness, I'm so sorry. I keep going forward in slides. So for all of those of you who are like, why do I need to know this? We don't have a union at our workplace. Again, this is just a quick reminder. It's already been stated this morning that the National Labor Relations Act covers almost all private sector non-supervisory employees, regardless of whether they have a union or not. And that means that your employees are covered by the protections afforded by the Act, even if they don't have a union or want a union to represent them. So finally, we're on the right slide. And I dusted this slide off from last year because, well, it still holds true. So now President Biden is in his 2nd year of presidency. Is it 3rd? I guess 3rd. And I guess it's 2nd, technically. And his pro-labor agenda has not changed. So despite the not so favorable coverage he recently received from unions with regard to averting a near railroad strike, he is still the most pro-union president in history. And it's a title that he's very proud to claim. And he's made good on his agenda for reconstituting the board with members that have very strong union ties and backgrounds, and also in his appointment of General Counsel Jennifer Abruzzo. If I get it, oops, no, I've gone backwards. There we are. So let's talk about General Counsel Abruzzo. So she's a career attorney with the National Labor Relations Board. Now she is the head attorney, the chief attorney at the board. She's been there for over 2 decades. And so she's risen through the ranks, and she was even acting general counsel under President Obama. So not surprisingly, she left the agency during the Trump administration, no shocker there, as Trump installed his choice of general counsel and board members that aligned with his pro-business agenda. So during her short sojourn from the agency, she worked at Communication Workers of America. Many of y'all might know that one. It's one of the largest labor unions in the US. And then last year in 2021, she was nominated by President Biden and confirmed by the Senate to her current role as general counsel. So I added a quote from GC Abruzzo that I think really sums up her perspective of the core purpose of the National Labor Relations Act. And that is not to focus on employers' rights and employers' interests, but rather to focus on organizing and promoting unionization. So I'll just say this bluntly, because she does as well. General Counsel Abruzzo does not see herself as a neutral. She believes that the board and the general counsel are empowered by the act to promote unionization. So she's not here to level the playing field or create neutral laws that balance the unions and employees and the employer's interests and finds a suitable middle ground. Instead, Abruzzo has said repeatedly that her focus will be on employees' rights to unionize, which means making the process of unionizing easier for unions. And generally speaking, right now, this is a popular position. This position is not new. So unions and pro-labor experts have been pushing this kind of labor reform for years. And now with Ms. Abruzzo, they have a champion for their cause, and she sees herself as the one to recharge unionization in the United States after decades of union decline. So let's talk about some of the changes that General Counsel Abruzzo has said that she seeks to make. And this is again to make unionizing easier for unions. So please note, she has published several memos that can all be found on the NLRB's website, laying out her agenda, which is quite broad in scope and might take us all day to unpack. So I'll spare you, and I'm only going to look at a couple of her agenda items. So on General Counsel Abruzzo's wish list is returning to the Joy Silk Mills Inc. doctrine. That's a mouthful. So what the heck is that? So first, let's set the table and discuss how most unions are formed today. So typically when a union holds a union drive at a business, they will collect union authorization cards from workers. This authorization card demonstrates that the employee wants to be represented by the union. And once the union has authorization cards from at least 30% of the employees in a specific bargaining unit at that company, the union will file a petition for an election with the NLRB. Sometimes the union, if they collect over 50% of cards from employees, they'll go directly to the employer and ask for the employer to voluntarily recognize the union. But currently, the employer has the right to say, no, we need to take this through the NLRB process. So then the NLRB takes it from there by resolving disputes between the employer and the union and processing a secret ballot election, either in person or now since COVID by mail, counting the votes and then finally certifying whether a majority of the employees have decided to form or not form a union. During this time, the union and the employer may launch campaigns to provide their perspective on unionization. The election process and so on. So it gives both sides time to talk and to educate employees. So now back to Joy Silk. So Joy Silk is a very old case back from 1949, and it was abandoned nearly 50 years ago. So it gave the NLRB power to compel companies to bargain with the union that secured majority support from workers through authorization cards rather than going through a secret ballot election process. So some experts are very excited about this, right? They say that, that it's important to give unions the quickest and fastest path to securing unionization at a workforce. And some other experts say elections better capture how workers feel about a union. And this is because the lead up to the vote typically gives the union and the company time to make their case to workers as to why they should or should not unionize. It also is important to know that secret ballot boxes can be very important because employees feel a lot of pressure and a lot of discomfort from both sides of the campaign. And so being allowed to vote in a secret ballot process that is overseen by the National Labor Relations Board truly gives employees that secrecy they need and just takes the pressure off. But again, on the other hand, pro-union supporters argue that giving employers time to mount a campaign against a union is unfair and harmful to employees' right to join a union. So if GC Abruzzo gets her way and the board agrees to return to the Joy Silk doctrine, unions will seek recognition from an employer without going through the NLRB's secret ballot box election process. All the union would be required to do is collect unionization cards from a majority of the employees, that means 50% plus one, and put them in the hands of the employer. Then boom, you've got a union. The only exception would be if the employer can prove that they have a good faith basis to doubt the majority support, whatever that means, right? So I think that means that the employer would have the burden of proof that the union was lying. Good luck proving that. Or that the authorization cards were fraudulent. Again, good luck in proving that. So as a very important side note, typically when unions launch an authorization card campaign, it is in secret, and there are very stringent attempts made by the union and the employees that are organizing to keep it from the employer. So that means that returning to the Joy Silk doctrine would allow, and in fact, even promote, I think, these clandestine organizing efforts, and you may have a union at your business before you even know that organizers are in your midst. So the conclusion here is simple. Abruzzo wants to make it easier for unions to win without an election. So as this continues to progress at the board, we'll update you on its progress. Also topping the list of items for GC Abruzzo in 2022 and 2023 is to eliminate the captive audience meetings. So for over 7 decades, employers have held captive audience meetings. So these are mandatory employee attendance meetings during which company leaders have the opportunity to explain the organization's perspective on labor unions, how the organizing campaign works, employee rights during organizing campaigns, and the right of employees to form or not form a union. So please understand, during these meetings, company leaders and management cannot threaten, they cannot coerce, they cannot make promises of benefits to employees for forming a union or not forming a union. That is illegal. And I know there is a sense that employers who want to have these captive audience meetings are anti-union, and that is the whole purpose of gathering employees together is to launch their anti-union spiel. And it's just simply not the case. I have many clients, and I've been involved in many campaigns where the employer is actually neutral. The most important thing to them is that they have an opportunity to make sure that employees are fully aware of the election process, what's expected of them, and what the employer and the union can and can't do during that process to make sure that employees' voices truly get heard at that ballot box. So holding these meetings is recognized as one of the most important employer strategies for discussing unionization with employees, and in fact, presenting an argument against joining a union if that is the organization's perspective. So certainly employees hear a lot of arguments from labor union representatives for unionizing. So the captive audience meetings are crucial to the employer's ability to communicate the other viewpoint. But GC Abruzzo wants to make these meetings illegal. And why is that? Well, again, it's an attempt to make organizing easier for unions by taking away the tools that employers have to make sure that employees are fully informed of their rights, how the organizing process and election works, and also to give the employer's perspective of having a union. According to Abruzzo, in a memo that she issued in April on this topic, her perspective on this is pretty interesting. She says that forcing employees to listen to the employer's perspective on unions and labor relations in general is inherently threatening. Like we just discussed, we all know that the National Labor Relations Act forbids employers to threaten employees if they form a union or promise them benefits if they don't form a union. We can all agree that that's bad and employers shouldn't do that. But GC Abruzzo goes a step further and says that requiring employees to sit through a meeting while on the clock and being paid carries with it the same force as an explicit threat of discharge or losing benefits if the employees dare form a union. So it's a stretch and fraught with vagueness. And what comes to my mind is, what about clients and employers that have regular mandatory meetings? I mean, a lot of my clients have daily meetings before each shift. And if this law goes into effect, will those have to be restricted so that management can't discuss or respond to questions from employees about unions or organizing or labor relations or you name it? And the answer is we just don't know. So at this point, the big question is, will this union-friendly board agree with the general counsel and make these meetings illegal? And I guess it would be time for my crystal ball. And I think that it's likely that the majority of the board will take the opportunity, if given, to change this 75-year-old law. So given how unabashedly political the labor board has become and flip-flopping depending on who's in the White House, this board may find these meetings illegal based on their overall goal to issue pro-union laws. I will say, however, that courts have the ultimate say, and many labor experts think that it's unlikely that the courts will go along with overturning this long-time precedent. Not only because it strays from long-time precedent, but also because it would violate the employer's First Amendment rights. What? Did you know that companies had First Amendment rights? Well, they do. So again, we will keep you informed as this works its way through the board adjudication process. And the issue is currently being raised in one of the Amazon elections. So the board may have the opportunity to rule on it in the next year or two. Really quick before I leave this topic, I must remind Oregon employers that we have a state law that prohibits these mandatory employee meetings at which the employer expresses its view about unionization. Under current Oregon law, these meetings must be truly voluntary. There is a strong belief that our state law violates the National Labor Relations Act, but we have yet to have a test case to rule on that issue. There have been other cases, one in fact was brought by the National Labor Relations Board to challenge the statute, but the court determined that the board didn't have standing, and that case was dismissed without addressing the merits of the challenge. So with all of these union-friendly initiatives at the board, we should not be surprised to see a dramatic increase in unionization. So union popularity is at an all-time high. Union approval ratings are up at 77% among young adults, which I would like to consider myself, but sadly I'm not anymore. And more than 3/4 of the growth in union membership since 2017 has come from people that are younger than 35. Also, workers who earn $40,000 or less are more likely to support a union, and that's at 72%. And also, I will say that the high-profile attempts to unionize in places like Amazon and Starbucks has really fired up all types of workers across all types of industries all over the country. In fact, the National Labor Relations Board reported out this fall that during the first 9 months of the fiscal year 2022, that's October 1st through July 30th, union representation petitions, those are the petitions for union elections, filed at the board had increased by 56%. That means that in the first 3 quarters of the fiscal year, petitions for union elections exceeded the total number of petitions that were filed in all of fiscal year 2021. So it is an understatement to say that there is an increase in interest in unions. So because of this, President Biden is proposing increasing the board's budget by 16%, which working with the NLRB as much as I do, I think that is greatly needed because they are very understaffed for the amount of increase that they're experiencing. So what is animating this groundswell of support for unionization? Some of it has to do with a younger workforce. The past 2 years, or is it 3 or is it 4, have brought about colossal changes in the workplace. Workers have gone through a lot, and I should say we should all put ourselves in that category as workers who've had to endure significant shifts. Some workers were laid off or furloughed. Some had to quickly adjust and learn the new skill set of remote working, which means working while homeschooling. Some were declared an essential worker and required to maintain a status quo mentality while the world around them shut down and was full of unknowns. And so this shifting mindset has led to activism and employee empowerment. We also have younger workers entering and making up a large share of the workforce. And with them come new ideas and perspectives. So it shouldn't be surprising that today's Gen Z and millennials seek to unionize to address issues of social justice in the workplace, which is a very different motivating source than we've seen in the past. Those voting for unionization in recent months indicate that they are primarily frustrated by their ability to influence their employer on social issues of today. So their concerns include things like climate change and immigration, rights for transgendered people, and a host of other issues that fall outside of the normal topics that motivate employees to unionize, typically like wages and benefits and leave laws, those types of things. So generally speaking, Gen Z and millennials are demanding control and power over their employers and the cultures of their workplace. They want a voice, and it's really hard to fault them for that. So with this new set of motivating factors, are employers to install a new set of labor relations strategy? And the answer is not really. The strategy should be the same, right? So the best strategy to have an engaged workforce and positive relationships with your employees is to be, wait for it, a good employer. It really is about creating a workplace where employees want to be and there's a sense of belonging. And that means that they feel valued and recognized and heard. So the solution is easy. We all know what the answer is, but putting it into practice every day, and that means every single day, is the hard part. So I'm just going to name just a few steps that might make this amorphous concept a little bit more concrete. So first is to ensure that HR has up-to-date policies that are readily available to employees through handbooks and through trainings, through reminder emails, and most importantly, through leadership and their how they conduct themselves in the workplace. It's also important, and employees want to see that employers are taking strong positions on preventing unfair labor treatment in the workplace. And that can be as easy as having clear anti-discrimination, anti-harassment, anti-retaliation, anti-bullying policies, DEI programs, those types of things. And not only that you have the policies on paper, but that you're revisiting them and you are kind of walking the walk. And also, it's important to have a true open door policy, not just one in name, but one that employees can see. It's visible to employees and it's actually utilized. is to evaluate your wage and benefit programs to ensure that they're not just competitive externally, but that they are also internally fair and consistent. Nothing gets employees riled up as much as when they perceive that the employer is not fair, and that also includes your compensation schemes. So make sure that you're providing a wages and benefits that are actually recognizing employees' contributions and rewarding their growth and commitment. I mean, obviously, this all has to be consistent with federal and state equal pay laws, but really designing programs that recognize employees is very important. Third, leaders and managers must be well trained, and this is so critical. And not just well trained on the policies, not just well trained on the actual operations of the company, but on the culture of the company. And that's really what HR and the personnel office is all about, right? The culture of the company. They need to be able to exhibit to all employees what that culture is. So your leaders should be relatable and have the ability to create trusting and authentic relationships with employees. Because employees who don't trust their leaders and managers will look to unions to solve their workplace problems. It's just the fact of the matter. Finally, I would say look for ways to give workers a voice in the workplace. So they want a voice in how policies are made, what the policies are, what the practices are, and what the culture is. So it is very important to get your higher ups to go, quote unquote, walk the floor and talk to workers in a meaningful way. If you have headquarters that is in a different location than your workers, get in your car and go get some face-to-face time. I realize that might be virtual face-to-face time, but the point is, don't be some untouchable stranger in the corner office. Look for ways to open up lines of communication and thought sharing between the decision makers and the workers, because typically where decision makers are out of touch with all levels of employees, those are the conditions that are ripe for organizing. So that is all I have for you this morning. Thank you for your attention. And now I will turn it over to our last presenter, Blerina, who will be discussing the ADA.
Okay, here we go. Thank you for your patience while we switch screens, and thank you for coming here today. It's wonderful to see some of the familiar names here on the attendee list. Hope to see some of you in person next year. But in the meantime, we wanted to wrap up this webinar with probably the most prolific topic that we have seen this year, certainly in my case, and one of the most dangerous, which is our good old friend, the ADA. On any given week, I probably get across my desk about 3 to 4 questions about the ADA, and they are becoming increasingly more complex and new. It's not that the fundamentals of ADA law have changed. We will cover some of those, and I know many of you are seasoned professionals at those. It's the way in which we are seeing the ADA be implemented and used that has changed significantly. So my plan for today is to start by covering some of those fundamentals as a refresher. We will try to fly through those a little bit quickly to get to your questions, but also because I know a lot of you are familiar with them. And that will allow us to shift into what has changed and some of the trends that we are seeing, and more particularly to do some practical hypothetical examples that will illustrate the ways that we are seeing the ADA manifest itself. Before I do that, I will put a big pin here for you to remember. Usually, we used to see the ADA come hand in hand with the leave statutes, the FMLA, OFLA, and other state counterparts, sick leave, and of course now the paid leave law. They used to create what we would call a Bermuda Triangle, but now it's a Bermuda trapezoid. That has kind of shifted over the last year. It's still very common, but there are some ADA trends that have shifted away from leave use. I will try to focus on those. But at the very end of this presentation, if we don't have time to cover it, you will see in the materials, we will distribute those slides, some hypothetical exercises that kind of throw everything together, the leave laws and the ADA, and provide you the solution so you can study on your own time how complicated this question has gotten. So put a pin on that and remember to look at it. And then right next to it, I want you to do something else. I want you to put up a Post-it and write down these words because they're the most important words I will tell you today. Hope you've got a pen ready. Write it down. Say, this is crazy, call the lawyer. Got that? I can hear sort of some laughter across the pixels in my head because it's actually true. The way that these laws are colliding has become probably the most complex I've seen in my now 16 years. So with that dire warning, let's get started on what has not changed, right? What are those fundamentals of the ADA basics? The main ADA principles are still the same. You still cannot discriminate against qualified individuals with a disability. As an employer, you still have to provide a reasonable accommodation for applicants and employees with disabilities that allows them to perform the essential functions of the job. And it's not just the individual with disability who is protected, is also an individual with a known association to that person. What is a disability has also not changed. It still remains very easy and broad for employees to establish what a disability is. I won't read through all these slides, but probably the majority of you know now that a disability is simply a physical or mental impairment that substantially limits one or more major life functions for an individual. It's a notoriously fact-specific inquiry, right? We still don't have a comprehensive list of disability examples, but what we do have is new kinds of disabilities. For example, we now have long COVID. We have different complications associated with that. And we also have seen a fundamental spike in mental health related disabilities in either getting exacerbated or triggered because of the pandemic. Another thing that has stayed the same is the individual still needs to be qualified for the job, meaning that they still need to be able to perform the essential functions of the job with or without a reasonable accommodation, right? They still have to have the skills to do that job. Similarly, the way we analyze essential functions, those legal fundamental principles of essential job functions remain the same, right? The position is essential if that's the function is essential if the whole reason for the position is really to perform that function. We still look at a lot of the same factors, things like the amount of time an employee spends on that function. What does the job description say when prepared before the interview and before the recruiting process? What the experience of the other employees that have completed this position do before. But one thing that we have added now because of experience is what has been the current and past practice of performing this job, meaning things like working remotely. Even though we used to believe that a specific job required physical presence, what is essential now has changed. Employers are still allowed some discretion in their judgment about what is an essential job function, but ultimately there are some of these other facts that we are finding are controlling more. You all know what the fundamental duty is when it comes to reasonable accommodations, and it's that you have to provide a reasonable accommodation, right? Not the accommodation that the employee requests, but a reasonable accommodation, unless doing so would impose an undue hardship on the business. And then, of course, the other side of that coin is that you have to engage in the interactive process with the employee or applicant to determine what accommodation is necessary and reasonable. We still don't have a magic word or process that triggers the interactive process. It still can be very informal. Largely, we've seen it now becoming remote instead of in person as it used to be. But the whole point of the interactive process remains the same, which is those four little words: how can we help, right? The employee still has a duty to inform you. The employee still has a duty to inform you if they need a reasonable accommodation. But remember that that doesn't apply when the disability is or should be obvious. The ways in which this is becoming implicated these days is with using words like, I'm struggling lately, I need to focus on my self-care, I need some time off for doctor appointments. I'm having trouble refocusing. So they're not coming up with these direct things. I have depression or I have anxiety. They are saying, the employees are disclosing this in more indirect ways. And the employer needs to continue to stay alert, because that kind of knowledge could trigger the obligation to engage in the interactive process. And the employer, of course, still has to give you enough information about the disability, right? You still have the right to ask for some healthcare questionnaire to determine what the limitations are and what the proper accommodation is to address them. The fundamental principles of reasonable accommodations, you all know that. I summarized them on this specific slide without getting in too much detail for a lot of them, but the big things that you don't have to do, right? Those have not changed. For example, you never have to eliminate or reallocate the essential job functions, right? Those are essential for a reason, and the ADA does not require that you remove them. It requires that you provide an accommodation to allow the employee to perform them, but not to restructure the job so that those essential functions no longer exist. You also don't have to lower production standards of quality or quantity. That is something else that the ADA didn't used to require, and it still does not require. In the Ninth Circuit, there are some exceptions for conduct behavior, right, in other states, which can be relevant because you might have employees that work remotely now. In other circuits, that could be unacceptable, but in the Ninth Circuit, there is more tolerance for conduct-related type of behavior that may be related to disability. You still don't have to pay overtime. You still don't have to breach a collective bargaining agreement or a seniority system or promote the individual with disability. These are still okay, kind of hard lines that we have seen upheld by the courts. And that you also do not have to give the exact accommodation that the employee requests. However, one thing that has always been the law, but is becoming more practical these days, is that the ideas of reassignment and unpaid leave are last resorts. We are seeing an uptick in ADA litigation related to employer decisions to just place the employee on unpaid leave, right? And a lot of courts are saying not so fast. What other analysis did you do to see if there was another accommodation that would have allowed the employee to continue to work, remain active, and of course, earn money? So those two things, reassignment to another position and unpaid leave, are last resorts in the ADA analysis. Only if you have exhausted all other options and there are no other reasonable accommodations do you reach this part of the analysis. So the other question I get a lot is, Blerina, what about undue hardship and direct threat? And this was really hot at the beginning of the pandemic, particularly with unvaccinated employees and COVID. And unfortunately, we have not seen any change in either the law or the way that these two defenses are being applied for employers. In fact, they continue to remain very hard to prove. They still need to be very fact-specific, very individualized to the specific employee, not to that disability in general. And undue hardship still requires a significant amount of difficulty. The ADA expects and requires employers to incur some burden, right? That's baked into the law. It's only when the difficulty and burden becomes significant that the ADA tries to kick in and protect you. But it's getting so hard, particularly for a lot of bigger employers. And big it's not taking a lot to qualify as big these days under the ADA, right? So it's taking a lot to establish significant difficulty. I still have to see it in the last several years. And the same with direct threat. I have seen some employers use it at their peril, and it hasn't worked out well because it needs to be based on reasonable medical judgment, right? It can't be what Google tells us about a specific disability. It cannot be what our own stereotypes tell us about a specific disability. Direct threat has to be based on objective medical evidence about that specific employee and how that specific employee is experiencing the disability themselves. So this is sort of the nuts and bolts, cover those fairly quickly. What has changed now, though, is what you have heard all of my other co-presenters do, which is we have the world has changed. And in the world of the ADA, we are seeing those changes ripple across sort of three buckets. And I'll start with the first bucket, which is the nature of work has changed, right? You've heard a lot about hybrid or entirely remote workplaces. I won't get too much into those. A big one, a big change that is implicating the ADA is multi-state workplaces. A lot of employers unwittingly, no good deed goes unpunished, right? But they became multi-state workplaces when they started accommodating employees working from home, from example, from Vancouver, from California, from Idaho, Montana, New York, London, Albania, my home country, I guess. So what has happened is that now, even a small employer with 15, 20 employees is now operating in 5, 6 different states, and they don't realize that they have to comply with the law of the land where the employee is located. That means that the federal ADA, which is what we are focusing on, certainly applies if you are subject to it, but more importantly, so do the state ADAs and other state rules, wage and hour, leave laws, etc. The other thing that has changed is the nature of our jobs, right? Some duties that used to be essential now have become marginal, and vice versa. The most prime one is obviously physical presence. We used to not be able to even envision performing our jobs remotely. And now many of us cannot envision doing them in another way and going back to the old ways. Similarly, communication types have changed. The way people are receiving and wanting mentorship and training has changed. So generally, the nature of work has changed, as has the nature of workforce. You heard Kristin talk about where employees are right now, which is how empowered and how outspoken employees have become. And I will say it's probably at a peak that I have seen it in my last 15, 16 years as well. They are a lot more savvy. They are a lot more informed about their rights. And this has led to good conversations between employees and employers, right? We understand them more. We can take better actions that will make for a productive working relationship. However, it is causing also heightened conflict, because in addition to being empowered, we're also seeing a very, very significant rise in health awareness and mental health condition. Some data that I saw recently was staggering by saying that an approximate 60-70% of our population reported either depression or anxiety at some point in the last couple of years. That number was actually a lot more staggering among attorneys, but definitely in the general population at large. And employees are more willing to talk about it. It's not as taboo as it used to be. And then, of course, you probably have all seen these terms of quiet quitting and quiet firing. They're both sides of the same coin, when either party, the employee or the employer, do kind of the bare minimum with the hope of the fact that either one or the other will end that relationship. And it's happening. Employees are more mobile, and this is certainly a labor market still. That last bucket that I've put in all of the changes is the nature of society, but really what that means is of juries, of judges, of investigators, and the way that they are willing to look at ADA cases. The biggest surprise, perhaps, in this change has been as a result of all of the social justice movements that we experienced. That has implicated the ADA in unexpected ways. However, not surprising once we stop to think about it. When we think about Black Lives Matter, the Me Too movement, sexual harassment, these have brought to the forefront a lot of trauma for many employees. And a lot of them are willing to speak out about it, and they are willing to ask for accommodation. So we are seeing ADA accommodation requests related to those issues at an unprecedented rate. I have a hypothetical where we'll discuss how they are showing up, but I wanted to flag it here. Another thing that has changed significantly that a lot of our clients are struggling with is this idea of trial by Twitter. And what that means is that an employee is taking to the social media long before he gets to the courtroom. Some of that is a result because of state laws and state regulations have largely limited, particularly in Oregon, California, Washington, they have limited largely what an employer can require that remain confidential. So employees feel very empowered to go to Twitter and Facebook and Instagram and talk about discrimination or harassment or distress and depression that they are experiencing. So this comes with reputational risks, which are very now closely entwined with ADA in ways that we haven't seen before. And of course, we are seeing these multi-generational differences that kind of started before the pandemic, but they have come to the forefront now in terms of lifestyle, priorities, and of course, ease of technology and communications. So what does this mean, all these changes? What have they created in the world of the ADA? Well, essentially, they've created a perfect storm for litigation. At the beginning of this pandemic, on our very first Zoom, when we were all trying to figure out how it worked, I actually see some names on the attendee list here that were on that Zoom. We predicted that on this other end, we would see a huge spike of ADA litigation. And this is one thing where I don't like being right at, because that's exactly what's happened. The ADA complaints are the highest since 2016. And this is both in courts as well as in agencies. The EOC filings have risen by 36.7%, I think. And in fact, the EOC itself has just filed its very first lawsuit related to remote work. This is not going to be the last, but basically in this trend of lawsuits that I expect the EOC to continue to file, they are pursuing the theory that an employer fails to reasonably accommodate an employee who asks to work remotely. And in that case, this specific employee was denied remote work after working remotely successfully during the pandemic. The other thing that we are seeing is a change in ADA evidence and litigation, which is coming from healthcare providers. Healthcare providers are working a lot more patiently and closely with their employees. And I have noticed two things. One, obviously slight delays in medical documentation, but two, we're also seeing that healthcare providers are a little more likely to sign off on employee requests, right? We used to get a little bit more pushback, a little bit more inconsistency between what the doctor recommended versus what the employee would ask. Right now, at least in my experience, I'm seeing them match and work in tandem a lot more closely. So, and then obviously the biggest change that we are seeing is what is or will be considered a reasonable accommodation, right? So let's do this. I will start with the top 5 accommodation requests that we are seeing across the board. And if you talk to plaintiffs or defense attorneys aside, and even investigators informally, they will agree that by far and away, when it used to be that the top accommodation request was leave, now leave, if you can see, doesn't even appear in this top 5 list, right? What is coming up for ADA are other types of accommodations. Remote work, by far and away, right? There's remote work, and then there's many empty seats, and then there's these other 4. And that's self-explanatory. Long COVID-related accommodations are actually quite common. They relate to things like brain fog, memory issues, breathing issues. They come up as requests for more frequent breaks. For example, employees who cannot stand or sit for extended periods, they need to lie down because their lungs are so severely impacted, or that they need instructions in writing, or they need to record everything because their memory has been so significantly impaired. And then accommodations related to social justice issues. We have a hypothetical, a practical scenario. I'll go over through that. Those have really spiked, and they almost always surround either remote work because the workplace is triggering racial trauma, or changes to the social interactions in the workplace. They are very difficult, very loaded, and you'll see why that is. Pets was a surprising one, but it's very common. People got pets during the pandemic, but also they found that pets can help their mental health conditions. The Jobs Accommodations Network reports a huge increase in requests for accommodations for pets. If you're going to make me come to work, I got to bring in my parrot. And of course, the last one are exemptions from mask requirements and vaccines. So let's do some of this, right? Let's start with this exercise 1 and the way it's coming up quite a bit. So in this case, we have a mental health condition. By far and away, probably the most common kind of requests that I see. These are, by the way, based on things that we are handling. We've removed identifiers for it, but they're not made up. These are actually things that are coming up. So in this case, let's say the employee works in human resources, because why not? And during the pandemic, she developed generalized anxiety disorder, and it's usually triggered by social interactions. She also becomes very anxious when receiving or providing negative feedback. And because of the medication that she has been taking, she has gained a significant amount of weight, which has understandably led to her developing depression. So she comes in and she requests to work from home indefinitely. She does not want to be required to engage in situations that trigger her anxiety, such as negative or confrontational interactions. And she wants to attend all Zoom meetings with the camera on. So let's analyze this, right? How would you approach this if this was coming across your desk? And it probably has. Well, let's start from the beginning. Are we dealing with a disability? No question about it, right? Anxiety disorders, depression, all of that, sometimes medication side effects, they'll probably qualify, not probably, they will definitely qualify as a disability with just about any court in the land. And there's really no question here that a lot of these requests are because of that disability, right? They're not sort of out of the realm of us not being able to see a connection. So the real question is, are these doable given her job? The first one is working from home. And the fact of the matter is that if this employee has worked from home successfully over the last couple of years, or maybe not successfully, but you have not documented any performance issues, right? They've not been significant. I think it will be very, very hard for you to escape a denial of a request to work from home, at least the majority of the time, without getting hit with a lawsuit, just given the huge spike in those kinds of lawsuits that we're seeing. And the problem is that those lawsuits are still so new and pending that we don't know what the result and the outcome of them will be. So in the interim, you know, looking into our crystal ball, we think that this request to work from home would likely need to be approved, at least with some limitations, and we can help craft some of those limitations for you. For example, you don't have to say, well, indefinitely, no strings attached. Perhaps we say, you know, pending your performance. Maybe we need to be better about documenting if there are any performance issues, but generally speaking, this one would probably be a go, a reasonable accommodation in this new world, when before this, 2 years ago, it probably would not stand. Maybe there will be some situations where an HR professional does need to come into work, you know, onboarding, those sort of things. You could probably accommodate or start engaging in the interactive process in those. But generally speaking, a remote work would be reasonable here. That second request, though, which is to not engage in any situations that trigger her anxiety, that is really, really difficult. You know, part of her job, an essential function of this employee's job, is to provide, you know, evaluations, to performance reviews, which may not always be good. A lot of them could be negative sometimes. They may have to fire somebody, which certainly is confrontational. Having a restriction that says you cannot engage in any of these situations will bring up a very significant analysis of whether this employee is qualified anymore to perform this specific function. So what does that mean? Well, when a client calls me and says, Blerina, we got to fire her, or we have to put her on unpaid leave. And that's the difference that we're seeing, right? A huge gray area between we cannot do this one and firing, right? We might still reach that conclusion of separation, but first there are several steps we have to go through, because remember, we still have to consider reassignment. We still have to consider other options, even if this employee is no longer qualified for this specific function of her job. We have to look at the documentation for that. What percentage of her time will be spent on firing? Is she an HR director or is she an HR professional? Is she usually in charge of onboarding, or does she really handle workplace and workforce management? So I think that one, you probably are better off if we're looking, or safer if you're looking into a crystal ball of denying, but not full denial. I think an alternative reasonable accommodation would be needed, or at least contoured around what it means to engage in these situations. And this probably would require a close working with her healthcare provider. That last one about allowing to attend Zoom meetings with the camera off, also very common. Again, crystal ball here, we haven't seen this get litigated yet, but my guess is that a court would probably say that most of the time that might be okay, unless you're having a termination or some other serious meeting where clearly a more face-to-face interaction would be important. Let's try to do the second, there we go. This one is racial trauma, very common now, and unfortunately extremely complicated and painful for everybody involved. This is another one where we have changed some of the facts so they're not identifiable, but also extremely loaded and very risky for employers right now. In this situation, let's say employee is a Black male who works as a software engineer, and recently he was assigned to a white male supervisor. He reports that the sound of a white male voice triggers painful memories of discrimination and racial trauma. Likewise, negative feedback by white employees triggers those traumatic memories. And he requests to work only for a non-white female supervisor, and that he be permitted to have a Black witness present for all meetings with any individual in position of power. Let's try to parse that out, right? We always start at the beginning. You cannot do any shortcuts in the ADA analysis. And that beginning is, do we have a disability here? You know, discrimination in itself is certainly a social wound, but really the disability here, the issue will be racial trauma, right? And we're still trying to understand that, but there's no question that it is real. And so some working with a healthcare provider in this case to figure out what exactly this means and what are the needs of this specific employee would be and is actually very, very important in this case. Usually what we're seeing this come up with is with some form of mental health post-traumatic stress disorder being unearthed, or some other, depression, anxiety. So there's no question, I don't think, that this employee, if they got the providers, their doctor's support, which often they do, will be able to establish some form of disability, or at least leave enough ambiguity there for you not to be able to just say, no, we can't deal with this. The real trick here is the kind of requests for accommodations that are requested, right? The first one is to work only for non-white female supervisor, right? Before the pandemic, or before the social justice movements that we've seen, this request to change supervisors were almost always kind of written off as unreasonable, right? That you don't get to pick supervisors. You know, the conversation has changed significantly on that. It has become more of a, well, let's see what the reason is. Is it undue burden for an employer to assign this employee somewhere else? In other words, why are we saying no? Are we saying no just because on principle we don't want to do it? Or are we saying no because it truly is an undue hardship for us to change supervisors? I think this one is really tough though, because it's not just whether it's an undue burden, but it's, is it right? Is it reasonable to make supervisor decisions based on race and gender? And rightfully, some clients say, I don't feel comfortable with that. And this is still to be determined, but we are seeing a lot of certainly demand letters and pre-litigation conflict related to this issue. In this case, I think this would be very hard, and we would have to look, what we have done is look carefully at the workforce, see what other options were available to the employee, while also being very careful about not violating discrimination laws. The other question, which is that he be permitted to have a witness, also used to be kind of an easy one before the social justice movements. It used to be that unless they were a union employee and had Weingarten rights, you didn't have to allow a witness present. Now, again, that has changed. We got to look at, is it an undue hardship to allow this employee to bring someone that makes him feel more safe in those meetings? Again, we do not have a case yet, right? We don't have a court decision yet that says yes or no on this specific fact scenario, which makes it difficult for you, because you're trying to avoid risk. You're trying to figure out how to manage this situation. Generally speaking, from what we have seen trend-wise, employers are getting more and more open and more likely to allow some witness in this kind of scenario. It snowballs though, because once the employee wants to bring their own witness, so does the supervisor, and then all of a sudden you're having to mediate. These are very complex cases. If you do come across this, do reach out to an attorney. The earlier, the better. Otherwise, they can get quite ugly because they don't just implicate the ADA, but they implicate Title VII and other laws in ways that we have not seen before. Another very typical example here is masking. I won't delve too much into this because you've probably all seen it, but it's basically when an employee is not vaccinated for a religious reason, but they also want an exception or an accommodation from the mask requirement. In this case, we're seeing, for example, breathing issues, or we're seeing traumatic memories, you know, a near assault, for example, and they request not to require a mask. Again, problems have risen when the employer simply says, nope, you got to wear a mask, or you have to work remotely or be on unpaid leave. Look at other possible options. Is there a way to change their workstation to an enclosed workspace? Could you change their schedule in ways that they're not interacting that much? Certainly, if they're interacting with the public, that might be a different scenario. But where we're seeing a lot of problems and pretty high demand letters come in is when employers just say, nope, you got to wear it. It makes other people feel uncomfortable. You will see here, we'll probably just, save some time. I won't get into all of this, but if you've been watching Wednesday, you will know what my inspiration was for these scenarios. But I do want to walk you slightly through this. This is what happens with leave combinations and once we throw everything together, right? You saw some of these tables in Jordan's presentation, but I've given you two exercises that I want you to spend some time with and kind of use as guidance. And in this situation is Morticia Adams when she was having baby Wednesday, right? This first scenario deals with the fact that, she suffered and developed some gestational diabetes during the pregnancy and then required bed rest. Some of you have seen this scenario before. Now is to show you how this would be handled with paid leave law as well, particularly after baby Wednesday is born on December 13, 2022. Pay attention to the year because it matters, right? And if you go into the answer here, I have parsed out exactly how this would play out under FEMLA, OFLA, sick leave, ADA, and of course under paid leave. And you can see that her disability during the pregnancy will be entirely covered under OFLA, not under FEMLA, because she's not eligible. She's not been working there for a year, right? She was hired on May 1. Sick leave, the ADA will also kick in, right? For a lot of things like gestational diabetes and bed rest, they will cover it as a reasonable accommodation. Paid leave, she's still not eligible for it because it starts in September, like Jordan said. And then, of course, because of OFLA, once baby Wednesday is born on December 13, Morticia also gets 12 weeks of parental leave, slam dunk. Here it is where things get extremely complicated, right? Because once she comes back to work and completes her 1-year anniversary, she needs time off because Gomez's father has a heart attack and needs care for 2 weeks. Then baby Wednesday gets a cold and Morticia needs a week off work. Then Morticia herself gets a knee replacement surgery on September 2nd, 2023. Remember that date is important from what Jordan said. She needs 3 weeks off. Then on Wednesday's first birthday, new leave year, Morticia fell at work while rushing to wrap up her work. Gets a concussion, broken wrist. Some of you have seen this pattern before. Goes to the hospital, gets staph, and then becomes an alcoholic. So she needs to go to rehab. And of course, then weekly AA meetings and wants to work home for at least 6 months to avoid the temptation. Take a look at this chart. Again, I'm going to try to save some time here so we can get to some of your questions. I won't go into all of this, but look at what happens here, right? You have got the paid leave kicking in for a lot of it. So once she enters, she needs knee surgery, a lot of Morticia's leave will not only be available, but will also be paid. And then take a quick look that even though she exhausts OFLA, once she enters alcohol rehab, it has re-upped in a look forward year. So she can take a lot of time off and then check out the ADA, right? Continues to protect her all the way through the remote work and the weekly AA meetings, even though FEMLA and OFLA are exhausted, and then paid leave ultimately will become exhausted. So that is the one thing to be careful about with the ADA and leave. It doesn't exhaust. It only has limitations on undue hardship and direct threat, but it's not something that can exhaust when you're not talking about indefinite leave and some of those other common tenets. So spend some time with that, and then wrap it all together by saying, you know, what should you do next about the ADA? Don't take shortcuts, right? This is a very hot, very dangerous area right now. So know the law and partner early if you need to navigate some of these difficult ones. Train your managers to recognize and elevate ADA issues to you. Update your job descriptions. You've heard us say this before. And then give a quick look to your processes for accommodation requests, particularly in the remote world, including confidentiality of medical records. That was what I had. Sorry, we had to fly through some of that quickly. We want to end by thanking you very much for making time for us this morning, particularly in December. We know it's a busy month, but hopefully you have gotten some helpful information to get your policies in order and get you ramped up for the next year. And we will see you soon. We will do this again. Thank you very much.